started because we have very little time and our presenters are already worried about not having enough minutes to present their whole paper. So let's have some compassion. 10 minutes for a whole thesis, it's a challenge. So my name is Nelly Stertieva. I'm the executive editor of the European Data Protection Law Review, which my colleague Bart will hand out to you personally in a second. We celebrated recently our 5-year anniversary, and now we're having our 4th annual Young Scholar Award. So almost since the inception of the journal, we are running this award, which it's a competition that invites young researchers to submit their thesis, and the best 3 authors are invited here today to present their work to you. But I will stop here and hand over to Bart, because really we had this conversation about keeping it short.
Okay. So I'm Bart van der Sloot. I am the manager, editor, or the editor-in-chief of the European Data Protection Law Review. So the process is always the same. We do a general call for papers for the Young Scholars Award. This time, as always, we get around 30 submissions. I selected 10 best ones. Then the 10 best ones are sent off to the jury, and the jury selects the 5 best, and the 5 best are all published in next edition of the European Data Protection Law Review. And the 3 best are selected to come and present here today, and the best one will get like a big prize honor, which is awarded by Serge Goodwirth, which is an honor by itself to be in the light of Serge. So today the order of things will be that we have a presentation by Johan, then someone will comment from the jury, then a second presentation, then again a comment, and then a third presentation, then again a comment. And in between, after the comments of the jury members, you are invited to post critical comments and feedback, which they maybe can also take into account when finalizing their article to be published in EDPL. So your critical comment is really important for them as well. I'm not part of the jury myself, but I'm stepping in for Maya, who was part of the jury and couldn't be here today. Okay, so without further ado, can I give you the floor to give the first presentation?
Thank you. Hello everyone, I'm Johan Peters. Last year I ended my advanced master LLM at KU Leuven about intellectual property and IT law. My thesis, on which I based my article, had as title Data Protection in Mobile Wallets. I will give a short introduction on the concept of mobile wallet. It's basically a mobile app where you can store your credit and debit cards, and this makes it possible to execute mobile payments. So it's convenient. It ought to be convenient for the customers. But it's more than that. You can also store your loyalty cards, coupons, purchase records on it, and merchants can also use it to send you some vouchers or some reduction, actually kind of advertising. So they use it as an integrated retail platform. Now, shortly about technologies. So actually the system is based on the traditional bank card transfer, but here it's special because they can use a whole range of technologies. For example, the near-field communication technology. This is used for proximity payments, so where you're in the presence of the merchant. But you can there's also the chip technology, and basically this is also what they use this is the secure element in the mobile phone, where the credentials of the user are stored. I will tell you shortly about Apple Pay, how the card enrollment process works. So the user puts his authentication data, his card data, in his mobile phone. There they send it to the Apple server, where it gets encrypted, and then they send those encrypted data to the bank. Could also be another trusted party, but in this case it's the bank, and they make a token out of this data. A token is a randomized number, so this is a kind of secure option, because the merchant in the end, when there is an execution of a payment, the merchant only gets the token, so will never get the real data, and only the token is stored in the wallet. But tokenized data stay personal data, because they are easily reversible. If you get the code to detokenize it, you will be able to read the original data. Now, in my thesis, I made a comparison between the GDPR and the Payment Services Directive 2. And I will tell you first in a 4 sentence or 2 sentences what it's about, although it's a very difficult piece of legislation. But actually, it came out because they wanted to allow new players in the market before there was a legal vacuum. So they wanted to make legislation about it, and they created the statute of the payment initiation service providers. So those providers can be actually fintech companies, for example, can get a statute as a payment initiation service providers, and they can offer initiation of payment on behalf of the customer, but they need, of course, their explicit consent. By executing the payment, those providers use the network of the online, so you have an online bank account that is used, but it can be done without an actual card. So in that sense, mobile wallets that use that use a payment initiation service provider can be a very cheap solution. You don't have to get a card from a bank. You only need a bank account. Now this is the simplified figure of how a payment transaction would work. The consumer decides to use the PISP to execute payment. The PISP will get in contact with the consumer's bank through an application programming interface. So this is the secured phase. Also in the PSD2, there is a whole so the EBA had to develop standards about this API, it's about the secure communication. Now, and then the consumer's bank will tell the merchant's bank the consumer's bank will tell the PISP that there is enough money on the account, so the payment transactions can be executed, and the merchant will get the message that he can deliver the product. It blocks. Here. So an important asset of the PSD2 is that the obligation for payment service providers to apply strong customer authentication. So from now on, before entering that bank account, you have to use two of the three elements have to be used. That is knowledge, something only you know, that's a password. Then you have the possession, only what you have, that's your smartphone in this case. And inherence, something you are, that's, for example, a fingerprint. And those elements have to be independent from each other, so if there is one in breach, then that the other elements would not be compromised. So this is what is in the legislation. But the problem with the PSD2 is the lack of data protection provisions, though there are genuine concerns. For example, in traditional payment cards, there was already a lot of personal data that could be deployed by financial institutions. You had the transaction data, the type and location of the shops could be taken out of it. But in mobile wallets, everything is multiplied because you can use, you can have several banks. The service provider can see the transactions on all your accounts. But next to that, you have also the browsing history, your smartphone, and your geolocation. So this can make a complete profile of the user. So all the bells, all the alarms should be red, because in this case, also if you know that all the fintech companies, the small but also the bigger, Facebook, Google, could use this to start a new business, a payment business. But in PSD2, there are not really, certainly not enough provisions that relate to data protection. The second point is here that in mobile wallets there is a multiplication of stakeholders. So you don't have the banks and the user and the network, but here you also have the issuer, you have the mobile network operator, the secure element issuer, and so on and so on. A lot of third parties can get involved. This raises questions of responsibility, basically. Also who informs the consumer, and then everything has to go on this small screen of your mobile phone. I mean, all this information first have to be available, and then second, the transparency obligation has to be fulfilled, but it's very difficult without real provisions in the law. Then briefly, the question is, because PSD2 is specific, sector specific, is it then a lex specialis? I would say no, because in the PSD2, R is one provision and one recital that refers that data protection legislation has to be applied to the processing of personal data for the purposes of PSD2. And the board already confirmed this point of view, that the interpretation needs to be done in the light of GDPR, so it's not a matter of subordination. Then I will point out the three incompatibilities. The first is in PSD2, in that Article 94, there is that all payment transactions, all the processing of personal data should be with the explicit consent of the user. Now, what consent is this? Is this a GDPR consent? This would be very difficult to implement because GDPR consent may be the legal base to prevent, you would not like to use, because it's so difficult to demonstrate that the consent is freely given, informed, specific, and unambiguous. And then imagine that you have the consent and you can prove, and then the user withdraws the consent. Then there are compliance problems too. Now, here the board decided that the explicit consent under PSD2 is not the same as the consent in GDPR. But because payment transactions will be, so the legal base will be the performance, necessity for the performance of contract. So this is an interesting point of view, but this will only for the essential, so the essentials of the contract. If you read the guidelines of the Working Party 29. So they are very strict. It has to be about the essential of the contract, and that's basically the payment function. But what about the storing of the purchase records and about the advertisement? I will come to that if I have a couple of minutes more. The second incompatibility, there is actually only one provision that alludes to the data minimization principle, and that is when you pay, when the provider gets in contact with your bank, the bank can only answer whether there is or there is not enough money on the account, but it cannot give you like an overview of all the transfers. It's only yes or no. But the problem here is that the providers can also use their own authentication procedures. So it's also a matter of compliance, a problem of compliance of banks. They have to allow the access on the bank accounts of their users, but they are not sure whether their customers are fine with this, because they have to rely on what the provider tells them. And here a possible solution would be a digital signature. Now the third, this is about the targeted advertising actually. There I will just mention it, that it will be very difficult to get targeted advertising without an extra consent of your user. Yeah, and I thank you for your attention, and I will be able to.
Beste Johan, dear Johan, that means in Dutch. I read your paper with great pleasure, I must say. I find it a real good contribution in an area where there is still some clarification needed, I think. When you look at PSD2 directive on the one hand, on the other hand you look at the GDPR, you can see that there's all kinds of difficult compatibilities. You addressed it quite well, for instance, by explaining that explicit consent is something completely different in the GDPR and in this directive. I liked it, I must say. I also liked a lot that the fact that you gave us an insight a bit as me as a lay person, for instance, how this technology actually worked, and that you on that basis started with your analysis. That was good, I think. It was nice to read. It was pleasant to read, so that's why you're here, probably. I also think one of the main, there are some things which you could really think of further, but I think you did it already. What I find the most fascinating, basically, of this whole thing, if you think as a citizen, is that basically PSD2 allows that third parties have access to your bank account. That's how I understand it, and that's something which, as a citizen, I would say, is that what am I happy about? It is the case. It's new technology because a lot of technology work together. I also understand that when you talk about targeted advertising as a result of this access, there should always be consent. That's clear, and consent should be then that should be GDPR consent, I presume. So no pre-ticked boxes. Maybe you should refer to the recent Planet 49 jurisprudence case law as well. What would I like to learn more? What I liked a lot. I said maybe a little bit. As a data protection lawyer, which I am, I always think about what is the legal basis. Is it really only consent, or could we also use contract here? Could we also use legitimate interest? To what extent? I think those are questions which I would find interesting to learn a bit more. But your paper is ready, so you don't worry that I will not ask you to write it in your paper. There's one question which you addressed not here in your presentation, but you addressed in your paper. You talked about special categories of data. And then you said you had the example, let's say if you pay, with this system, if you pay with in a gay bar, for instance, with this POMA. Then we deal we might deal with sensitive special categories of data. I would be interested how that will work out in practice, and if this is actually possible, or if our systems, if the GDPR in those cases prohibits you to use this mobile wallet in these kinds of environments. That's my question for you. But all in all, I would say this is good work, and thank you very much for writing it.
Thank you. Yeah. Yeah. Okay. Yeah. Thank you a lot. Thanks a lot for your comments. To answer you shortly, actually, whether you would be possible to pay. Yeah, no one blocks you from using that phone, that application wherever or for wherever you are, or what product you want to buy. The thing is whether it is it has a legal base at that moment, because that is the problem where there is not yet a solution for. I refer in the paper to the research of VLM bins, but they want, especially concerning special data, sensitive data, they were looking for ways to turn them into normal data, or to give the consumer to decide about whether those data can be shown or not. But this system, in my opinion, is not yet completely finished, so they should do more research.
Okay, thank you. We have time for one question. Yes.
Hello, Angelica Fernandez from University of Luxembourg. I actually have, I'm interested because, as you say, a strong customer authentication is used across all the fintech. And generally, it has to be you have to get right 2 out of 3. And then you say that, what I understood that you said that that's not really like consent as in GDPR. But however, one of those 3 elements normally, and that's under the anti-money laundering directive, it needs to be like, and most of the time is a contract that you go to your bank, so it's very explicit and then it's very informed, and you're just giving unambiguously your consent as per the definition of the GDPR. So I wonder how do you see that, how you see that unfold in relation to what you said that is actually not in the GDPR. So I'm curious about it.
Thank you for your question. I think that it is not your bank that you have to give your consent to, because the bank is obliged to open up the account from the moment that the provider asks it then. But you mean also the contract with the provider or with the bank? Yeah. Yeah, we will discuss further later, because I think it's the next speaker.
Okay, thank you for your presentation. Then up to the next one.
Hello, everyone. Sorry. Okay, you can listen to me. Well, first I would like to thanks for the opportunity of being here. My name is Thiago Moraes, and my thesis research, which this paper comes from, is entitled A Spark of Light in the Going Dark, Legal Safeguards for Law Enforcement Encryption Circumvention Measures. During the presentation, each one of these aspects is going to be explained, but very briefly. I will not be able to go into in-depth because I only have less than 10 minutes now. So feel free to read my papers and the other colleagues as well.
You have full 10 minutes. So,
okay.
Yeah.
Thank you. So the case goes around the going dark phenomenon. And what is it? The going dark is this phenomenon of encryption being used for communication services and equipment. Basically, we have been seeing this more and more over, but it's not as a recent discussion as we might think, because this discussion has been going on since the 90s. And I just bring here two more current examples, which were two cases involving the FBI in the US. One is now at the San Bernardino case against the Apple iPhone. And another one, it's a case that's still ongoing of Facebook Messenger. And the law enforcement authorities trying to reach evidence which is contained here. So what we can see is that there are at least two different interests which are in clash. One public interest, which is the law enforcement interest of providing, collecting evidence to be able to investigate and pursue criminal offense, and the other side, the right to privacy. I try to tackle it by this big question, which is broken down in 3 sub-questions, and I'll try to provide you with some findings of each one of these parts. So, starting with the technological part, I assessed the 2 big environments that this happens. The first one is data in transit, so basically the channel of communication, and many times what we've been seeing is the adoption of end-to-end encryption, which provides a way that the whole channel is encrypted and the key is stored in the end device, which means that the service provider doesn't have access to it. We see this in WhatsApp, we see this in the Facebook Messenger, and other kind of instant message service, many of them based on the Signal protocol. And the other one, which, yeah, I am forgetting too fast, sorry. The other one, which is the one of data at rest, is the encryption of the end device. So this is what we see in the case of the iPhone or the iPhone iOS or Google Android. And this means that the key is stored, for example, inside the phone device. So once again, the manufacturer has no access to this key. So, which are the measures that have been being implemented by law enforcement authorities? I split in 2 groups, the technical ones and the legal ones. For technical ones, we have backdoors, we have key scroll, and what I call government hacking, which is actually an umbrella term for many hacking techniques, just meaning when these hacking techniques are applied, enforced by legal authorities. And in the other side, we have the legal measures. So for the legal measures, we have the encryption ban legislations, which is basically some attempts to ban the use of encryption. This has happened in many countries around the world, but fortunately so far we don't have any official banning encryption legislation. Well, some might disagree, but and the other one are what I call the unlock orders, which basically when the law enforcement authorities go into court to request a right to access the key that's held by the owner, which of course cannot be done every time. And this is one of the problems of the end-to-end encryption solution or full disk encryption, because even if it's considered the legal right for this authority to access the evidence, the service provider doesn't hold the key. And I bring in this assessment that some of the solutions have this feature, this character is called the bulk effect, which means that in order for you to apply them, you have to apply them to everyone. And these three are backdoor, key and scroll systems, and encryption ban laws. So for this, I concluded that there's no way of you to find a balance because it's very extremistic solution. Which brings me to the point that there are two other measures which are left. And maybe here, by applying the right safeguards, we might be able to find this balance. So which are those? Well, we have both in the European Charter of Human Rights, the European Convention of Human Rights, and the European Charter, the protection of the right to privacy, which also applies for communications. And in this context, encryption should be this tool for exercising the right to privacy, could be one of these tools. And this also means that these rights, as rights that can be interfered under certain conditions, we have to understand what are those certain conditions. Well, the conditions that we can find, broadly speaking, in these two charters are legality, legitimate aim, necessity, and proportionality. So what I've done is basically trying to access via case law of the two courts of these jurisdictions and also some national legislations, what could be these minimum safeguards and also some best practice that were implemented by these national legislations. And the legislation I analyzed was the UK, Germany, France, Netherlands. So first, I found out what they call substantive safeguards, which are related with scope and duration. And for scope, it's both related with, first, the nature of the offense, which means only serious crimes should be considered for you to enforce this measure of circumventing encryption. And the other is the categories of people targeted. That should be as much single target as possible. And the principle of necessity comes here because in some situations, like a communication channel, it's just impossible for you to target only one person. There's always be some spillover. And for the duration, it's very important that this measure has the same timeline of legality of the surveillance operation. For procedure, I start to analyze that many of these procedure safeguards, which actually can come after encryption was already circumvented, so it's important to understand that it also applies to the data that was collected via that. They are connected with many data protection principles that we can find in the policy directive. So we have for data security, the integrity and security of system data, non-disclosure of data minimization can be connected with the deletion of non-relevant data, and the storage limitation can be interpreted as destruction of data after use. And of course, what's very important, we have oversight, and as Zakharov has taught us, it has to be applied in 3 moments, before, during, and after the surveillance. And then in my paper, you can find brief explanations for each of these aspects where oversight is part. And transparency, and this is very important, oversight and transparency have some connection, which is in the part of the notification safeguard, but there are other aspects of transparency that should be reminded, like reports, which mean that these authorities should be at least implementing like annual reports of statistics of how many times these operations are done, and also no gag orders, which means that the service providers should have the right to inform the public when they are being surveilled.
Can you round up?
Yeah, I am finishing. And this means, well, I have here the best practice that we will have, unfortunately, to read the paper, or fortunately for me, to be more aware of. These conclusions were basically already said. I would just call the attention that while I provide the government hacking, both unlock orders could be considered, we have also to consider the difference of these two techniques, because government hacking seems to be more effective because it can actually bypass both end-to-end encryption and full disk encryption in some situations, but it also brings more security risks. So, and also requires high expertise and resource. And that's basically it. It's also what my phone says. Thanks a lot.
thank you, Thiago. So I was part of the jury, and I think the jury was very convinced of your paper. It is a really good paper. You offer a good and practical overview of the case law, and I think you have also a good structure, and the article, of course, deals with the topic of enormous relevance at the moment. So we were very happy to read the paper, and you really had a good structure and a good insight into which kind of legal safeguards actually apply and should be in place in relation to accessing encrypted data. I also have to say you bring complicated measures to the point, and you explain it in a very reader-friendly way also for me. So it's a very like encryption for dummies a bit, but it's really good because very understandable, and to explain it in that understandable way, you have to understand it by yourself, and I think you did, and this was really a good part of the paper. What I also really liked was the overview of the case law. I think this is a good point. When we come later to the measures you derive from that, I have some criticism, but it's only superficial. Maybe you could divide a bit the criteria by which are essential to really implement and which are maybe not that essential. And I also, but maybe this is in your thesis and not in the paper, maybe explain a bit why you choose these 4 countries. This would be also interesting. And there's one thing, but maybe it's not in the paper, but maybe you could improve it a bit. You derived it from the case law, and the case law was related to surveillance measures, but also to law enforcement. And I mean, you know that EU law and also ECTHR law distinguishes between national security and between law enforcement. And I couldn't see this divide in your paper, but maybe you did it by purpose. Maybe you can answer that afterwards. There's also a difference in terms of EU powers and political agreement when it comes to national security. So I would maybe pose the question or ask the question whether this was intended. I mean, law enforcement and national security measures are mixing, so this might be one reason to do that in a way. You did. Otherwise, I would love to have an explanation of that, and this would add much, maybe 2 or 3 sentences to your paper just to explain that. This would be really good. And there are just 3 smaller points. I think one sentence would be good to explain why the case law with dealing with bulk surveillance and data access is really immediately relevant to encryption measures. This would be also interesting to know. I mean, I think it is, but needs some kind of theoretical underlinement maybe. And the role of the law enforcement directive. You just touched it there, but less in the paper, so this would be also a good thing. But in the end, it was really, we really liked the paper, we appreciate it. It's a criticism on a very high level, and I can just recommend to read the paper and to enjoy reading it, because it was really good.
Thank you.
Do you want to respond, or?
Yeah, briefly. Well, first of all, as you can imagine, it's very challenging. We were sharing that when we have to condense the information that comes from the thesis. So many of these things, not all of them for sure, there are some things for reflection for me, but some of these topics were a bit better explained on the full thesis, which you also all invited to read. So, for example, about the explanation of the countries, the national legislations, it was an assessment I've done. So first I tried to access as many national legislation could find. Of course, there are some language barriers there, but well, I tried to find some assistance on that. And in the end, I had to come to a decision. So I came to some criteria to decide about these countries. And they are usually related with countries that were implementing a lot of surveillance in this combative encryption circumvention in this particular context, or who had read some bold law on the topic. And about this difference about national security and law enforcement, I also addressed a bit better on my thesis, because yeah, it was a concern. And when I was still making the scope of the research, I decided, okay, for a master thesis, it will be very challenging first to try to address a bit of the tech for dummies, like you said, and then come to all the legal analysis. So I had to make choice. Yeah. And unfortunately, that had to be taken out. And maybe it was not very clear in the paper. But yeah, thanks a lot for the advices, and I take that
Thank
into
you.
consideration.
Questions?
Okay, we have time for 2 or 3 questions. Who wants? Not all at the same time. No. Oh.
If no one asks, I have another.
Hi, it's more a technical question. Can we trust on WhatsApp when they say they cannot read our messages or they cannot give the message to the authorities? Because I know that you have a technical background, so maybe you understand it better.
Yeah, so, yeah, are there more questions, or should I answer that one straight away?
And if there are any recent updates on the encryption policies of the companies?
Mm-hmm.
Okay, one final question.
Oh, now everyone. Oh no, not you.
No, it's a very simple. It's a very simple question, I think. Maybe you could comment a bit more on cloud storage and the role of backups in cloud storage and access to finding other ways to access the plain text, and how there are kind of institutional structures that are being moved around. Apple most recently, and iCloud, and so on, and what role you see that in tandem to the communication. Thanks.
Okay.
Okay, and you have 1 minute per question.
Okay. So, starting with the WhatsApp, well, what we can do as technicians is to access what we call green papers, which are basically like the idea of white papers, but like technical oriented, and they bring like what's the protocol and how it works, the technology. So I did that part to try to get some confidence, and also talk with some peers to be sure, like, okay, what that could make sense, and that's our way from the outside to access what's being provided without interfering like in trade secrecy rights and these things. So we can never fully trust, but if everything is done in the way that the green paper says, yeah, and well, if it was not happening, you can be very sure that the police would not be complaining so much. So that's what bring me some assurance that this might actually be happening. Analyzing like the policies, well, I cannot give you a clear answer on that because unfortunately I didn't have time to go into to see how these are being updated. What I've noticed, and this has been going for years, that it seems very convenient for companies to be on the privacy side in this moment, because for them, when they do that, they can, well, first of all, look as privacy vanguardists and privacy protector companies, and at the same time, they have a very sound reason to not having all this data, this content that they have to be being shared with these other institutions, which are also very strong law enforcement authorities. For the cloud storage one, well, I did a brief assessment on my studies on that, but more in the consideration that usually what we have is this is one of the situations that actually these unlock orders can be performed, so you don't actually need to rely so much on hacking, because many times in this cloud storage service, the key is in the hand of the service provider. But yeah, I'm aware that there are I read some approach to try to, privacy-oriented approach to make a way that you can have a cloud storage and the key is not there. But I wasn't able to really access that, so I don't, yeah?
When communications are backed up onto cloud storage, like WhatsApp communications are backed up in plain text onto iCloud, that's what I was referring to.
Oh, okay, but sorry, you're talking about the communication being stored there, but what's the question?
The question is, as an alternative route to access,
yes,
how that has panned out in the examples that you were looking at, but it's okay, that's just the...
Yes, okay. Yeah, because that, I don't think I would be able to give a proper answer without being more sure of what I'll be saying, so sorry.
Okay, thank you so much. And then up to the next speaker.
So, hi everyone. So, moving from encrypted data to data in clear sight, so to say, I wrote a paper about public-private partnerships, the use of publicly available data in the area of law enforcement. So just to give you a bit of background, I work in an EU project, it's called Titanium project, where we combine a lot of private partners and LEAs and researchers. So we have a very good insight what LEAs actually want. And so a key problem for LEAs is that they are increasingly relying on technological approaches that they are not legally able to use. So they want to access data that is publicly available, for example, on Facebook or so. But in the national law, there usually is no legal basis to do so in a broad manner, as they want to do. So what I observed during my work in the project is that they often refer to private parties to say, can you scrape this kind of data, or can you provide me access to this kind of data? And that brought up the question, is it possible for LEAs to overcome their limited capabilities, technical or financial, by using public-private partnerships? So if we talk about this question, it's necessary to look at different layers of problems. And what I observed in the discussion, we often talk about AI or analysis, and well, it's a really broad discussion, but I think it's necessary to break it down to individual layers of the problem. One problem is probably the public availability, because for illegals, of course, under European legislation, personal data is still protected if it's publicly available. It doesn't make a lot of difference. Under US legislation, however, it makes a difference. And if we look at the Europol regulation as well, they can actually access publicly available data very easily, and they don't fall under the GDPR. So there's a lot of confusion between different parties, and we really need to be able to find a way to find a consensus what public availability means and what the legal implications are. I won't go into detail on that one because it would take too much time. Similar on data sources, we need to discuss what data sources are available and what are the legal implications. So obviously it makes a difference if we talk about an open data platform with research data, or if we talk about publicly available data from a social media network. So we should find a consensus if we want LEAs, for example, to be able to work with this data or not. Same for analytical methods. That's actually going, it's a huge topic which needs to be addressed on its own as well. But we need to be able to see who is using what analytical methods, so who's framing the research question, for example. If we look at data science, who's doing the collection, who decides what is collected? Is it a private party or is it an LEA? Because they have different interests, of course. And last but not least, and most important for the presentation today, are the processing constellations. So in my paper, I looked at various constellations. Today, I will only present one of them, and really need to think about what kind of consequences that has. And in the end, based on all these problems, I try to find a solution to some of them at least, and include a proposal that's still work in progress, so I'm really looking forward to some feedback on that. Okay, so getting to processing constellations, I try to visualize it somehow, and on the bottom left you see a private company who has as a business model scraping data from the surface web, for example, and they provide this data to whatever customer is interested, usually based on a subscription model. So usually you just get an API you can access, so you send a request and get a response based on the analysis that was conducted prior to that. Most private partners I talk to say, well, this data collection is based on the GDPR. It's our legitimate interest. It's a business interest, so we're basically allowed to do it. And in many cases, they say we also do research, so some research exemption also apply. So it's very helpful for them. And then they provide just an API to the LEA, and the LEA can access bits of the data or the whole data set, depends on the constellation. But let's say they can just access bits of the data. So the LEA says, well, it's not really an interference with fundamental rights because we only access that specific bit of information, so there's no problem. But if you look at the whole picture, that basically means the limitations the LEA has is more or less bypassed by using a private party that gathers data under the GDPR. So that comes with multiple problems. First and foremost, we need to think about, is this kind of data collection and processing even legal under the GDPR? In my opinion, it's not, because it's not a valid purpose or a legitimate interest. And the second problem is the constellation when the LEA accesses the data via an API. In this moment, it's basically a joint controllership. So because the company provides the rules how you can work with the API, and the LEA controls the actual request. So it's a factual joint controllership that is not implemented in the LED nor in the GDPR. So the GDPR is not working for law enforcement purposes, so to say, and the LEA, the law enforcement directive, on the other hand, requires a competent authority to be a controller under the LED. So it doesn't work well together. So in the end, you have two legal frameworks that should control one kind of data processing, and that's not working. And we need to find somehow a solution to that. To make it a bit more practical, I tried to find a real example that's not confidential. So we have a LEA on the one side that is usually using some kind of tool like Maltego or IBM's Analyst's Notebook. In particular, Maltego is very interesting because they have a community version which everyone can try. That's very interesting to see. And then Maltego just provides access to a myriad of APIs from third-party providers. And I know that many LEAs are actually using this, and it's not really clear what legal basis they have for that. I don't think they have any. So we need to think about ways to overcome this. And one way that came to my mind was to change the GDPR in so far that we have like a specific legal basis to provide specific rules for the collection of publicly available data for law enforcement purposes with very specific conditions. Let's say you can do it, but you can't use data from Facebook or social media or so. So it should be limited in some way. In addition to that, the law enforcement directive could be changed in so far that private parties would be accepted as competent authorities, or you just add private authorities, if you will. In this case, you would also need additional legal basis in the national law, which so far doesn't exist, and that's a general problem in this realm. I think that the national legislators are just too slow to keep up with the pace of technological evolution. But still, law enforcement, of course, always cries to get access to newest technology. So what I thought in the end would be maybe a good solution, I'm interested to hear some opinions on that, is to provide a legal basis for private parties to gather data for law enforcement purposes with specific conditions. But instead of providing them directly to law enforcement agencies, we have like an intermediary, which I here call the EDPS gateway. So ideally it's somehow located at the EDPS. It's like a technical gateway where the private parties can register, say, I want to do that, I want to provide data to LEAs. The EDPS can review the algorithms and the underlying approach if it's consistent with the legal basis for the private parties. And then, on the other hand, LEAs can send out requests to the EDPS gateway as well. They can check if it's valid, if it's consistent with the national law, and so on. And that would have some advantages, I think, because on the one hand, it helps to standardize technological formats. That's a very huge problem for developers. They don't know how to provide data to law enforcement in general, how this data can be provided to courts in the next step, because it's very hard to see how you can bring such evidence to courts. You could also, of course, implement access control, and you can limit the access, of course, and log all kinds of access. So I could imagine it would be very helpful to have a full log of all requests coming from LEAs in a certain case, and if you are a defendant in a trial, you could just go to the EDPS and say, look, I have this case, I'm a defendant, I want to see what kind of data was searched for in the internet by the LEAs. Because the current situation is often that data is brought to court, either nobody questions it or you question it, and then LEAs can't really provide a valid reason where this data came from and what data was searched in addition to that, or they just say, well, that's confidential due to IP law or so. So what do we take away from that?
Could you round up?
Mm-hmm. Yeah, sure. I'm on my way. In the current situation, I believe many of the processing constellations are illegal. LEAs flee into confidentiality agreements, so it's very hard for the public to get any access or information on that. That's really a tricky one. Of course, we also need to discuss if we want private parties to access publicly available data or any data for that matter for law enforcement purposes. So that's really a huge question, and I'm not really sure on that on my own. If we don't want that, we need the national legislators to provide sufficient legal basis to do to allow LEAs access to novel data-driven technologies, because in most criminal procedure codes it just doesn't exist. Same for police law. From my view and experience, the legislators are not able to do so because it's like a lot of politicians and don't have insight in the technical reality of LEAs or of developers. So I think it could be a possibility to make use of private parties who are experts in their fields and use publicly available data and machine learning approaches and help to provide their expertise to LEAs. And that's it from my side, I think. Oh, and of course I'm funded by the EU. I have to say that because they're paying for my expenses here.
Okay, this is the final talk, and I want to thank again Franziska Boehm and Hilke Heijmans and also Maya Brakan for being the jury members of this Young Scholars Award. Again, I'm taking the place of Maya on commenting briefly on your paper because we ran out of time. So it's very, very structured, almost German, I would say. Like you should read it. It has categories, subcategories, and sub-subcategories, and it makes it really understandable to anyone really engaging you with the topic. So it's really nice. You can also see, as already was discussed with the other papers, that it's sometimes a bit more concise than your real discussion. So maybe you could look again, maybe sometimes giving a footnote or making a reference to claims you're making. Oftentimes I agree with them, but for example, you say, prior to any processing, it is necessary to detect and define the problem that needs to be solved. I agree, but there are some people who say big data beyond method, etc., etc. So maybe you could explain a bit more. So my main question, which you could also maybe address right now, is you have a very interesting suggestion, and you list a number of advantages that could have, but I missed the disadvantages. So could you maybe suggest 3 disadvantages of your proposal?
Yeah, sure. So, of course, there are always downsides to solutions. I think the biggest downside, depending on the implementation, would be that if you include private parties in this scenario, they always have commercial interests, and this commercial interest basically is getting more data because that's a better service for your customer. So that's one point. If you have a centralized institution, from a practical perspective, I can believe it's very difficult to implement, to find standardized ways to share data. Still, I believe it would be a good time to start with that. So that's more or less a downside. And of course, a major problem with that could be that it interferes with the national sovereignty of the states. So LEAs, national LEAs, are not willed to have the EU dictate how they work, so they want to keep it on a national level. If you have, let's say, the EDPS controlling it, they probably wouldn't be very happy. So I'm not really sure if that could work out, but hopefully so. I could imagine it would be better, even though it has some downside, of course.
Okay. Who has questions?
Hmm?
Look, I just have a question about the notion of constellations. You were using the constellations, processing constellations, and also the recommendation at the end. And it sounds very, very beautiful, and it's I think it's probably accurate. But is it really legally sound to talk about constellations? Because I think we regulate processing operations, and you might have indeed constellation of processing operations which are complex, but still maybe that's how it works. So what's the autonomy of these constellations notion?
Wait. Okay, sorry.
I have another question regarding to your proposal for the EDPS to be a gateway. Apart from what you mentioned, the issue of national sovereignty, there's a second, more basic issue whether a supervisory authority, and the EDPS is one, should actually get involved in the processing of personal data at all, because it's the task of EDPS to control European institutions when they are processing data. So I don't know if anyone from the EDPS staff is here, whether this institution would like to store masses of personal data themselves. They would have to control themselves.
Yeah. Okay.
Can I make a question as well?
Yeah.
A quick one. In your research, have you considered some privacy-enhancing technology and how this could affect this constellation? For example, homomorphic encryption. Maybe it could, be a question suggestion for your research.
Okay. So I think I start with the second question. If the EDPS would be interested in doing that. I mean, it really depends on the actual implementation. You could, if they are just really an intermediary, they don't need to store huge amounts of data. They just control access to huge amounts of data that are still stored on the private side, so to say. You don't have to store it at the EDPS, but I fully agree. You could also give it another name and don't have it at the EDPS. Just from a data protection perspective, that's the first place to go to. And if we look at the reality of that, for example, Europol is working on systems like that. But I would feel much better if the EDPS would be the intermediary instead of Europol, because Europol has a complete different legal situation. Like, they have the Europol regulation, they can easily access publicly available data. They do it under their own mandate. So you kind of pull it out of the GDPR if you have this combination. So I don't know if the EDPS would be willing to do so. Maybe someone could answer that. No? They are not willing to do so, or nobody can answer it?
I don't know how much I can say as a trainee there, but like, Yeah, one thing that I'm aware, for example, that I was considering, first we have to consider jurisdiction issues because the DPS is concerned with EU institutions, so EuropeAL makes sense, but what about national authorities? And like what you said, the national sovereignty becomes a big case. And the DPB, would it be willing to access that? Well, yeah, it's a tricky, I don't think so.
Yeah, I mean, speaking of the Data Protection Board, like I wrote this in my paper as well because it's kind of funny, I think. They have a section on their website where they talk about guidance for law enforcement agencies, and I think it's there for over a year or so, but it just doesn't provide any content at all. So, I mean, it doesn't even say error 404 or so. It's just, there's nothing in there, and I actually asked one of the representatives yesterday if they plan to do so, and she was kind of angry. So they don't plan to do so. Well, still. Okay, coming to the first question. I don't know if I got it right.
We have 1 more minute.
Okay, I'll try to. If this constellation is sound, so the question is if we regulate processing instead of constellations, right? I believe we can't look only at the processing if we don't look at the constellation, because the processing in this specific constellation is just not regulated. It just doesn't fall either under the GDPR or the LED, so there's a gap between these two statutes. Happy to discuss it later on if maybe you have a different opinion on that. And the last question, encryption, I would have to ask to elaborate on that, like, and what point do you mean should be encrypted? Because we have the publicly available data on one side that's not encrypted, so we could encrypt it afterwards, but what would be the benefit?
No. My discussion is just like if some of these analysis that could be done, the analysis that could be done when it's with private parties, then we will be dealing with, like, if there's the identification, we could be dealing with like anonymous data. So it comes out of this scope of any of this directive or regulation on data protection.
I see.
We have to stop here.
And we can discuss that.
That's a tricky one, yeah. That's interesting.
Yes.
Okay.
Thank you so much. I want to ask Serge to come in front and award the yearly Young Scholars Award to the best paper.
I know my role is not important at all. I haven't read the papers. I am here just because I have a grey old man, I think so. But I learned a lot. I learned a lot from the three presentations, and I'm getting curious. So probably I will read the papers as well. And I wish I could stand here with 3 boxes, but that is not the case. And I'm not responsible for the choice. that is very convenient. So I will open the box and put the Oscar is. Yes, shall I? Do you want to know the name of the winner? The name of the winner is Thiago Moraes. All my congratulations. And but I would like the 3 of you to congratulate you and to hope you will produce